Mr. Vani?
Chairperson, good morning. Good morning, Commissioners. This morning we again have Advocate Ackerman testifying from Cape Town.
And that one.
Before we proceed, we undertook to put up the extracts from an affidavit made by former President Thabo Mbeki, in which he referred to the possibility of a shootout or a bloodbath between the DSO, the Scorpions, and the SAPS. Mr. Ackerman has pointed us to the affidavit in question, and as mentioned yesterday, it's the affidavit that former President Mbeki put up in his application to intervene in the litigation launched by the Lekanya Kalata and the other families. And with the leave of the Commission, we'd like to hand up those extracts.
Yes,
Chair, maybe I should join chorus with Morocco. Please give us these documents before you hand up.
We have made copies, and as mentioned, evidence leader, we only learnt about this recently ourselves, so we put them up as soon as we can. Sipa, please go ahead. We have made copies for the evidence leaders and others. We're only referring to 2 paragraphs, so this isn't a train smash by any stretch. And please hand out copies to our colleagues. It's a 180-page affidavit. We haven't printed all that paper, but I understand that electronic copies were sent to the Commission. But if we can highlight paragraph 73, where President Mbeki says that he told Advocate Macaulay that SAPS would oppose any attempt to search its headquarters. I also said that so bad were the relations between SAPS and the NPA and DSO that members of the SAPS might even open fire against the NPA search team. And then if one goes to paragraph 78, President Mbeki says, however, he conceded that indeed there might be a shootout at the SAPS HQ.
Mr. Vani, is it not better to identify them? And then when Advocate Ackerman comes in, he could deal with those, or they could be read into the record.
Yes, we can do that. He did make reference to it yesterday, but we will refer him to those passages.
Yes, I mean to avoid duplication.
Indeed.
So we have paragraph 73, 78.
Just those 2.
Oh, just these 2, okay.
With the leave of the Commission, we can then start with Mr. Ackerman.
Yes. Madam Chair, may I, with your permission, refer to the evidence I gave yesterday relating to Mr. Simelani's affidavit, and more specific to where I stated that I did not attend a custom meeting where a list was produced with ANC names, and it also referred to Lusaka and the meeting that the ANC members had in Lusaka. The record will reflect what I said. I think that was a gist. I think I said that I do not recall such a meeting and list, and I still, this morning, do not recall such a meeting, but I do know something about the people in Lusaka, the ANC members there, and I said I recall that I perhaps read it in a book, or maybe it is Wagenaar who told me about it during my interaction with him. with the Van der Merwe, what a case Van der Merwe had against the 37 ANC leaders. My concern was, however, how did Mr. Simelane know that I knew about it? Last night I scratched my brain and were looking for a list and thought about what list it could be, and that was passed around at the meeting. I was certain that such a list of names did not exist and that I never investigated any person in Lusaka. This morning walking from the hotel, I was still thinking about this, and then it struck me that perhaps Mr. Simelane was referring to one of the audit reports, that one that Chris McCannon drafted in 15 May 2003, and there were subsequent ones. This morning I went through all those audit reports, and I found no case regarding the atrocities or what happened in Lusaka. I didn't look at the obvious place. This morning, sitting here, I went through my personal notes, and I now know how I knew about it. I still don't know how Mr. Simelane knows about it. I will refer to it when I come to that point in my evidence.
Thank you, Mr. Ackerman. Before we proceed, can we just ask you to place on record the relevant paragraphs in the affidavit of Mr. Mbeki? You will recall yesterday that in your evidence you were testifying in relation to the apparent reasons put up by President Mbeki for the suspension of Advocate Bekoli, and you made reference to Mbeki's claimed reason of the ill feeling between the NPA stroke DSO and SAPS, and you made reference to a bloodbath or a shootout between those entities that Mr. Mbeki had made reference to. And I asked you, where did that come from? And you mentioned it was an affidavit that Mr. Mbeki had made. I don't know whether you heard, but we have put up the affidavit that Mr. Mbeki made in his application to intervene in the Kalata litigation of last year. Can I just check whether you have a copy of that affidavit or the extracts before you?
At the moment, yes, I have it, page 49.
And am I correct in saying that the relevant paragraphs that you relied on were paragraphs 73 and 78 of Mr. Mbeki's affidavit?
That's correct.
In paragraph 73, he makes reference to a fear that members of those groups may open fire. Well, at least in paragraph 73, he said, I also said that so bad were the relations between SAPS and NPA and DSO that members of the SAPS might even open fire against the NPA search team. And then in paragraph 78, a similar reference. Are those the two paragraphs you were relying on?
That is correct. Chair, if I may add, I read all the documents that were referred to me. I read this affidavit of President Mbeki 6 months ago, and I was always interested to know why was Mr. Bekoli suspended. Because in the press, I read about the irretrievable breakdown between him and the minister read about because of the TRC cases, and I kept it in the back of my mind when I wrote my note that my wife typed out, and that's where I then wrote it, that I don't believe, it's unbelievable, I don't accept it, that is the reason why Mr. Mbeki suspended Mr. Pikoli. There must be some other reason. Why I say I find it unbelievable is I can't understand it if an officer of the court applied for a search warrant. He's got a legal search warrant. He wants to go and arrest or search, and then Mr. Pikoli or whoever had that search warrant are informed that he must do it in 2 weeks' time. That's just another interference in the work of the National Prosecuting Authority, that you have to get the permission from the President before you can execute a search warrant. Because if you go further on, I haven't read it for some time, but that's somewhere in this document, it must be stated that Mr. Pikoli was still sitting there when he said, well, I'm going to execute it. And now I'm just paraphrasing because I read this document 6 months ago. He said he stood up and he went to his secretary, I think this is what the President said, and had a suspension letter typed and gave it to Mr. Pikoli, and Mr. Pikoli said, thank you that you are suspending me. That's how I recall what was said in that affidavit of Mr. Mbeki. I just find it unbelievable. And why say I find it unbelievable that today that there will be a shooting in the streets of
Mr. Vani,
Yeah.
with the chair's permission and Mr. Ackerman, I think it would be poignant, please, just to read into the record paragraph 73 and 78, because
As the
for the
Commissioner
record,
pleases.
if there need to be an explanation, it's fine, it could be done. Can you do that, please?
Yes, of course, Commissioner. Mr. Ackerman, as Commissioner Khoma requests, please will you read paragraph 73 and 78 into the record?
Chair, may I start from page 70 because it's we just read these two, and may I read the 10 paragraphs to get the complete picture?
Yes, you may.
Thank you. Paragraph 70, the President says, the next time I had to deal with this matter was when Advocate Pikoli informed me that he had a warrant to arrest the SAPS headquarters and National Commissioner Celebi's house. I then asked Advocate Pikoli to meet me at the official President's residence in Tshwane. I also invited DG Chikali to attend the meeting. During the meeting, Advocate Pikoli confirmed that he had applied for and obtained the said search warrant. He said that he had to execute it immediately or within a week. I told Advocate Pikoli that in my view, the SAPS would oppose any attempt to search its headquarters. I also said that so bad were the relations between the SAPS and the NPA and DSO that members of SAPS might even open fire against the NPA search team. I therefore asked Mr. Advocate Pikoli to give me a fortnight, 2 weeks, within which I would engage the SAPS and take all the necessary measures to ensure that the NPA and DSO carry out their searches without any problems. I also told Advocate Pikoli that I was surprised that he had sought a search warrant, knowing very well that I was ready to intervene with the SAPS as I had already done so successfully to help the NPA. Advocate Pikoli did not explain why he had opted to get a search warrant. However, he turned down my suggestion to delay the execution, the search warrant, undertaking to engage the SAPS so that the NPA could search the SAPS headquarters with no opposition after a fortnight. He insisted that he had to execute the search warrant within the short period he had indicated. However, he conceded that there might be a shootout at the SAPS headquarters, saying he based himself on what had happened when DSA unit had tried to search the Deputy President Jacob Zuma's residence at Forest Town.
In Johannesburg.
In Johannesburg. There's something, I recall something else. May I just have a minute or two to go through this?
Thank you, Mr. Thank you.
I think at that stage, or after he decided that he was going to suspend Mr. Pikoli there and there. That's my recollection.
Thank you, Mr. Ackerman. Unless there's anything else on this topic, perhaps we can move to the first subject you wish to address the Commission on today, which I understand is that of the forged letter.
Maybe whilst we are there, Mr. Ackerman, you have been withdrawn from the TRC matters and orally so. Mr. Pikoli is suspended. Did Mr. Pikoli, as the commander, rally his troops, you and the others, to a meeting and explain to you what has happened and why it has happened?
No, there was no meeting about why things were happening. I can't recall any meeting. I mean, I'm quite certain he didn't inform us that he probably did inform Mr. Hofmeyer, whoever was there, but it was all very sudden. I don't even know when he left.
Okay, thank you. Thank you, Mr. Vani.
If I may, yes, Ms. Moroka, there's documents all over the place. It's going to be so difficult to get a handle on them. And I wanted to find out from you whether you don't want to give this one an exhibit number.
Yes. Mr. Vani, should we give an exhibit number to the affidavit from former President Mbeki?
Yes, Chair. Can I suggest that we add it to Bundle 3 as item my attorneys have advised me that it'll be Bundle 3, Item 6.
Thank you, Ms. Moroka.
Thank you, Chair. Mr. Ackerman, are you ready to proceed in addressing the Commission in relation to the forged letter?
This is what the matter. Commissioner Como asked whether Mr. Pikoli had a meeting with us. I don't know what the position is. If a person of civil servant is suspended, on that day he's not part of the office anymore. So I didn't see that after that meeting he had with the president. He was suspended. I mean, the forged letter. During May, June 2003, I established that there were 395 dockets registered by the two officers Nell and Brits in the Advocate Fix office, and Nell and Brits were administratively in charge of those dockets, and I think the dockets were kept at the Rivera office on Church Square. I've given that evidence a few times now. I perused these dockets, made a decision what should happen to each docket. I testified yesterday that I started at the top of the pile, and in the respect of each docket, I compiled a short internal office memorandum setting out the facts and how the matter should be finalized. I discussed the problematic cases with Brits and Nell before I made a final decision. In the majority of the cases, the perpetrators had been granted amnesty and could therefore not be prosecuted, or inquests have already been held. These memorandum were not addressed to any person and were to be placed in the docket so that the status of this docket could readily be ascertained, like 23 years ago. I did it, and fortunately I had this note in this docket, so I knew what I did. Now, the forged note, and I will give evidence extensively on this forged note, is, I've got here page 110.
Commissioners, that's in the separate Ackerman bundle that the Commission, the documents that the Commission obtained for Mr. Ackerman, and it's at page 110.
I will refer to this document through all my evidence. I just noticed this morning, I cannot believe that I never picked this up. The page 2 is missing, and I asked the attorney to go through all the places where this was submitted, and I see even Commissioner Jacobs sent only page 1 and 3. I don't know where's page 2. I'll tell you why it's relevant later on. This note is a fabrication, and I'll explain later to the Commission what were the reasons for this fabricated document. These notes, there must have been at least 90 of them. You will see, I'll just see if I don't lose it now. It's a reference number on top, reference A15. That's when I started there. And navraag, Advocate Ackerman, and the telephone number. And it's addressed, it says to Ramayiti SC van A.R. Ackerman SC, and the date is 26th of June 2006. And at the bottom you will see there's my signature, and the date is 26/6/2000, and you will see there's also a 6, and that 6 is not my handwriting. I will deal with it later. As I said, these memoranda were typed by Mrs. Pienaar in McAdam's office. And the number that I gave it, A15, is a reference number that was in sequence. In other words, the one A14 will be A14 will be dated before 20. I can't refer to this document, but they were in sequence, and it were all 2003. I will deal with this. The fraud itself, the forgery, later on. What is very important is at the bottom of page 111, you will see under my name, there is struck TP. I know in the olden days that the person who types a letter, the typist usually puts her initials at the bottom of the letter, and that is Tiapina. Now, she left my office end of 2003 or maybe beginning of 2004. So it's not possible that she could type this letter. She was not there. But there are multiple indications that proving that this is a forged letter that we'll come to later. Just to give more background, later in 2004, Mr. Nuka resigned and Dr. Amiti was appointed the acting director. In late 2004, after Amiti received a telephone call from the Minister Mabandla regarding the Chikane arrest, I was informed by Dr. Amiti and Mr. Hofmeyer that they had attended a meeting in Cape Town with inter alia the Minister of Justice and the National Commissioner of Police, Mr. Selebi. They informed me that it had been alleged by National Commissioner that the PCLU was in possession of 400 dockets and planned to paralyze government by arresting key government officials who had been part of the ANC liberation movement. This allegation was not true, but as a consequence, I was required to assist Dr. Ramaiti to compile a lengthy memorandum to the Minister of Justice, Richard Mabandla, stating the correct position and again confirming that there was no investigation against the ANC leadership. I see there's a document to that effect. It is
perhaps I can assist you, Mr. Ackerman. That document is also in your separate bundle. It's in that document starting at page 7 of that bundle. And I think you're making reference to Annexure I, which has not been delivered as yet, as far as we're aware, from the NPA. So that's paragraph 22 on page 13.
Commissioner, I would at the later stage refer to the important documents. I think the input there is just that Mr. Mabandla was once again informed that there's no case against the ANC leadership. Subsequently, Advocate Pikoli was appointed as a national director, and in the beginning of 2006, guidelines for the prosecution of TRC cases were approved. In mid-2006, I was called in by Advocate Pikoli who informed me that I was once again being accused of acting irresponsibly and not informing him of my activities. I can recall that he called me in at least 3 times during those periods. But on 20th of August 2007, Advocate Pikoli drew my attention to an article which had been published in a report on 19th August 2007 and asked me to furnish him with a report dealing with the allegations in the newspaper.
If we can just pause there, Mr. Ackerman. That article in the Rapport newspaper, Commissioners, that's in Bundle 2 at page 42. And it's a report article dated 20 August of 2007, and it's titled Dossiere oorleies vergrype lê al jare inkleis ANC lees verdwyn by Sonia Carstens.
Yeah, I've stated in my personal notes, I said here in this report it was stated inter alia that Ackerman het vroeër skriftelik opdrag gegee dat die polisie nog getuienis in die ondersoeke na die ANC leiers moet versamel met die oog op 'n moontlike vervolging. Well, I wanted to see my memorandum that was filed.
Mr. Ackerman, can you just offer a quick translation of that Afrikaans,
It
please?
stated that I earlier gave an order that I gave him a written order that the police must be still look for evidence against the ANC possible prosecution. And that's why I then wanted to see my personal office note in that file. I contacted Commissioner Jacobs telephonically and asked him to furnish me with my memorandum. Shortly thereafter, he faxed me a document. It was the forged document. That is now again the 110 the forged document. But there was no page 2.
Sorry.
The document.
Sorry, the Ackerman. Chairperson, we have Ms. Nkloko on virtual with her hand up. I don't know whether she wants that interruption to happen now or at the end of the evidence.
Yes. Ms. Nkloko?
Chair, I'm not certain that my hand is up. The hand that is in fact up, it is Ms. Ranto's hand. I see all our hands are actually up. I'm not sure why. But there is no interaction. What I had wanted was a translation and then Mr. Vani dealt with it.
Thank you.
You may proceed, Mr. Ackerman.
Now, I received this document and I recognized a portion of the contents of the document as corresponding to the memorandum that I had compiled for the landmine docket in 2003. I recognized my signature at the bottom page 2 of the document, but noted that a 6, not in my handwriting, had been added to the date, which was in my handwriting and located next to the signature. I therefore immediately realized that this document was a forgery. As the document claimed that in June 2006, I made the following decision. Fortunately, we have a translation of that by Commissioner Jacobs. This is just for convenience sake that I can.
Please,
Yeah.
Mr. Ackerman, before you put up the translation, please would you read the Afrikaans portion into the record?
Ten opsigte van die sogenaamde voedseldata is geen verdere ondersoek nodig nie. Ten aansien van die ANC leierskap wat die opdrag vir die landmynveldtog gegee het en nie amnestie ontvang het nie, moet 'n besluit ter gelegener tyd nog geneem word nadat al die relevante bespreek is. Bovermelde is 'n moeilike besluit. Is that no? At the TRC task.
And Commissioners, just said that you're aware that extract is on page 111 of the Ackerman bundle at paragraph 4. That's the document that Mr. Ackerman says is the forged letter.
If I can refer to page 72, that's page 72 to page 77. In this, it's a report compiled by Commissioner Yops. I will later explain why he compiled this report. On the first page, he said the following. Advocate Ackerman indicated that, Commissioner, and now I'm going to read the translation of my Afrikaans now. The ANC had approved
Mr. Ackerman, before you proceed reading, we just want to make sure that everybody's on the same page. So you're referring us to page 72 of your bundle. Is that the document that is titled Report on Audit Document of South African Police Service TRC Related Matters?
This was a report compiled at the request of the task team.
Yes, and am I correct in saying that is the heading of the report?
That's correct.
And who compiled the report?
Commissioner Yops.
Thank you. You may proceed.
I'm just going to, the relevant part is the translation so that everybody can understand what I said. He says, it's his translation. He says, the ANC had approved the use of landmines and orders in this regard were given by the command structure of Nkonto Wisizwe to members of the amnesty judgment of those involved. According to the evidence, those mentioned were under the command of one Manchek, who gave orders and who had to report to MK commanders. All the other ANC members, foot soldiers, who were involved in these crimes are deceased. Advocate Ackerman made the following decision. In respect of the so-called foot soldiers, no further investigation is necessary. In respect of the ANC leadership who gave the orders for the landmine campaign and who have not received amnesty, a decision needs to be taken at the opportune time. After consulting with all the relevant parties, this is a difficult decision, close brackets. And then there's a date, inserted 26 June 2006.
Mr. Ackerman, sorry to interrupt you, but which page are you reading from?
That is page 72, and now I'm at page 73.
Okay, thank you.
On top of page 73, I don't know if it's...
Proceed.
Can I proceed? I will later give evidence to what's the relevance of that 26 June 2006. But I think what is important that to understand, when this report was given to the task team, that was, I did not know of the forged letter. I'll explain it later, but that 26th of June 2006 will be relevant later. If I may indicate, perhaps it will play a role to understand it. If you go to the whilst you look at this page 73, you will see it says, Advocate Ackerman indicated on 11th of August 2003 that the inquest must be held. That's not a different matter, but the relevant parties, he indicated on 11th of August 2003. At the bottom, there's a note that's not a note, it's a different case he deals with. On 18 August 2003, Advocate Ackerman decided that. You look at page 74, he says that 19th of August I decided. At the bottom you will see Advocate Ackerman on 3 October 2003 decided. Look at page 75, there in the middle it says Advocate Ackerman decided on 3 October 2003 that, and it's all translations. But it's only with this one matter where they've put in They don't say, I decided on the 26th of June, 26th of June, it's just a date that they put in there. It doesn't start off, if you look at page 72, stating, Advocate Ackerman indicated. That's the only one where he doesn't give the date. All the others he gives the date and it was in 2003. That is the only one that it's not done with the same style. So it's another indication that there was something fishy about this document. But I'll proceed and then we'll come back to the document again. I say the document contained a reference number A15, which would be consistent with...
Before you continue, I'm not quite sure where you are, but at page 75, Mr. Ackerman, whose handwriting is this teenspreeklikheid, which means contradiction? Whose handwriting is that? With reference to the statement Advocate Ackerman decided on 3 October 2003 that, and then the handwritten note teenspreeklikheid, which is contradiction. Whose handwriting is that?
I don't know, but I don't know. I asked for these documents, and I don't know who submitted it. It can be Yops. I think if I have to, let me see, I must have his handwriting somewhere.
And with Jacobs, is that a reference to Dr. Philip? Sorry, is that Dr. Philip Jacobs?
That's correct.
Okay.
Look at that handwriting. I don't think it's his handwriting. It might be this.
No, if you don't know. If you don't know, don't worry then.
Okay. Now, as I said, any document compiled by myself in June 2006 and addressed to Dr. Ramayiti would have been in English and would have been typed by Mr. Swart on her computer in a different format and font. Mr. Swart came after Tiapina left me in end of 2003. She was my the secretary. But in any event, an internal document compiled by myself and addressed to Dr. Ramayiti would not be in the lawful possession of SAPS. During a number of meetings with the TRC task team after June 2006, which were attended by Commissioner Jacobs representing SAPS, this matter was brought up, but a copy of the letter was never tabled. After I established that the document is forgery, I immediately report the matter to the National Director. He instructed me to request Commissioner Jacobs to forward the original of the note to my office. A letter was faxed to Commissioner Jacobs requesting him to have the document delivered to my office by no later than 1600 on 20 August 2007. The document was never delivered to my office, nor have I heard anything regarding the matter from Commissioner Jacobs. I will just give briefly the reasons I regard why this is forgery. General van der Merwe and his Foundation for Equality Before the Law on numerous occasions threatened the 37 ANC leaders with a prosecution if they dare to prosecute any member of the security forces. These threats of the foundation for equality before the law, even played out in the public domain. At Northshire, I was informed by the attorney of, I call him Fel, Jan Wagenaar, that General van der Merwe was in possession of a docket proving the guilt of the 37 ANC leaders. The government of the indictment was the so-called landmine campaign, which they admitted in their amnesty application that was not successful. I was informed by Wagner that the contents of the docket included inter alia, agenda, minutes, presentation lists, and decisions taken by the ANC at meetings. I think Lusaka was mentioned. This is what I earlier this morning said. I was looking, I knew something about Lusaka. And this was what Wagner informed me. And I don't know whether it was over the telephone or it was in my office, but it appears to me I did know about the Lusaka link. I was also informed by Wagner that senior counsel perused this document and was of the view that the prima facie could be made out against the leaders of the ANC. I have no doubt that the ANC leadership must have been very concerned about the existence of this docket. After all, they did apply for amnesty of the landmine campaign and it was refused. There was only one way out for the ANC to prevent a prosecution against them. And that was to make sure that no prosecution was instituted in the Shikani matter. The TRC team was a vehicle they used. The task team was, after all, created for the purpose to make decisions on TRC matters. That is the reason why the Shikani case played a very important role in the deliberations of the task team. And I will later deal with the minutes of the task team to see how many times Shikani came up and what the views were of the members of the task team. Virtually all the members were of the opinion that Shikani was not interested in a prosecution. Now, if the task team was unsuccessful with their attempts to prevent the prosecution, the powers that be must then get another plan. And that plan was to obtain evidence that Ackerman was still investigating the 30C ANC leaders. But the problem was that there was no evidence to that effect. So what is the next step? Documents must be fabricated to prove that I was still investigating the 37 leaders. I've made here a note now, play the role played by Commissioner Yops.
Mr. Ackerman, before you proceed to the role played by former Commissioner Jacobs, would this be an appropriate time for you to take a short break?
Yeah, it would suit me. Perfect.
Would 15 minutes be an appropriate time?
It would be fine.
Chairperson, with the Commission's indulgence, could we take a 15-minute break?
We'll adjourn for 15 minutes.
As the Commission pleases. Jacobs, I want to refer you to a document, Commissioners. This is in the Ackerman bundle at page 35. It's a memorandum addressed from Dr. Ramaiti, then Deputy NDPP, to Ms. Mabandla, then Minister of Justice. It's dated 22 November 2007. The purpose of the memorandum was to inform the Minister how the TRC prosecution-related matters have been and are currently dealt with by the NPA. Mr. Ackerman, I want you to read into the record the whole of paragraph 4.3 and its subparagraphs. But before I do so, can I ask whether you had any inputs into this document?
Looking at it now, I was of course taken off TRC matters as the 22nd November 2007, but I know that Chris McAdam wrote a letter and he discussed it with me. This is a repetition of many letters that we've written regarding the same topics. So I know of it. I don't know if I had any input or whether I read it before it went out. But it's under the name of, this went out under the name of Dr. Ramaiti. But I will read it out, 4.3. This is, I know of these things that are said there.
Yes, please go ahead. 4.31, it's titled Allegations Against the ANC Leadership, to 4.39.
Prior to the establishment of the PCLU, SAPS had compiled a series of dockets relating to the armed struggle of the liberation movements. In consultation with the DPP Pretoria, SAPS had appointed 2 retired police officers to manage these dockets. Although the suspects who had been implicated as being directly complicit with the offences contained in the docket had been granted amnesty, the 2 police officers were of the view that the prosecution could be instituted against the ANC leadership, which had adopted the armed struggle. In this regard, I realized on the refusal of amnesty to 37 ranking office bearers in the ANC by the TRC. For reasons unknown to the NPA, they were of the view that the prosecution should be linked to a landmine campaign. These 2 officers brought this matter to the attention of the PCLU after it was established. They were, however, unable to furnish the PCLU with any docket containing any evidence against the ANC leadership. At the same time, the PCLU gave notice to the lawyer acting for the former security forces that it intended to prosecute individual security force members for their role in the assassination of members of the liberation movement. The lawyer responded by stating that the security forces had compiled a docket against the ANC leadership, which would be used to obtain a private prosecution in the event of any security force member being prosecuted by the NPA. Due to these concerns, the then DPP, Mr. Muka, instructed the PCLU to examine the available case material in order to establish whether there was in fact any basis for such allegations. After the PCLU furnished Mr. Muka with a report to the effect that there was no legal basis on which a criminal investigation could be instituted against the ANC leadership, Mr. Muka released a statement confirming there were no grounds upon which the ANC could be prosecuted. This was done in May 2004. Because there was no basis upon which to investigate the ANC leadership, Mr. Muka further directed that all the police dockets relating to the liberation movement be removed from the DPP Pretoria's office by SAPS. This was done under the supervision of the then Director General. of Justice. Since May 2004, the NPA in particular the PCLU has regarded this matter as being finalized and has conducted no further investigations into such matter. The fact that this matter has been finalized was reported to the Minister and other key role players at appropriate stages. When the media speculated as to the prosecution of former Minister Flock and former Minister Commissioner van der Merwe in relation to the poisoning of Reverend Sekani, an organization called AfriForum publicly called upon the NDPP to either abandon the prosecution or to prosecute the AN leadership in respect of the landmine campaign. The NDPP informed AfriForum that the matter had already been closed by Muka in 2004 and that there were no grounds upon which he could overturn the decision of his predecessor, Dr. Ramiti.
Thank you, Mr. Ackerman. Let's now turn to the evidence you wish to put to the Commission in relation to the role played by Commissioner Jacobs. Commissioners, for the purpose of this section of Mr. Ackerman's evidence, he's going to rely on two main documents. That's going to be the affidavit of former Assistant Commissioner Jacobs to the Ginwala Commission. That's dated the 15th of January 2008. And that can be found in the Ackerman bundle between pages 61 and 97. And he will rely in particular on pages 61 to 69. And then the second document is an internal memo compiled by Mr. Ackerman, which was a response to that affidavit of Commissioner Jacobs. And that memo is in the same bundle between pages 105 and 129. Mr. Ackerman, you can proceed now.
I'll deal with the affidavit of Assistant Commissioner Jacobs to the inquiry of fitness of applicant calling to hold office. I will read out his each paragraph, and then I have a document. I know that Mr. Piccoli submitted this Commissioner Jacobs' affidavit to me, and he asked me to respond to it. And what do I have to say about this? So can we then start off with, first of all, the affidavit and paragraph 1.
So that's at page 61 of the Ackerman bundle, and it is the affidavit of Philippus Christoffel Jacobs before the Ginwala Commission, and it's dated the 15th of January 2008. You can proceed, Mr. Ackerman.
He says, paragraph 1, I'm making this affidavit with reference to paragraph 114 to 120 of the government's submission to the inquiry. I am an officer in the South African Police Service holding the rank of Assistant Commissioner. I'm the head of the component Legal Support Crime Operations at the head office of South African Police Service in Pretoria. Senior Superintendent Josiah Lekalala and I were instructed by the then National Commissioner J.S. Levy to represent the South African Police on the interdepartmental committee set up in terms of the guidelines of Cabinet to deal with post-truth and reconciliation matters. My answer, I will now deal on page 105, is my reply to each paragraph. I will do it seriatim. At paragraph 1, I then write, Commissioner Jacobs' affidavit was compiled with reference to paragraph 114 to 120 of government submission and not with reference to the minister's affidavit. In addition thereto, it must be noted that the TRC guidelines do not make provision for the establishment of any committee. That was my reply. Now I will enter paragraph 2 of Jacob's affidavit. He said, notice was given by the National Director of Public Prosecutions on 9 October 2006 of the first meeting of the committee to be held, and the National Commissioner invited to nominate an official to attend the meeting and also to attend the meeting personally. The first meeting was convened for 12 October 2006 at the National Prosecuting Offices in Silverton. The National Commissioner of South African Police did not attend the meeting. In effect, 2 meetings were held on that day. One chaired by Advocate Bukoli with the Directors General, and directly thereafter a meeting presided by Dr. Ramiti with the designated officials from the respective departments. I attended both meetings. It is reflected in the minutes of the second meeting presided by Dr. Ramiti that Mr. Mbeki of the Directorate Special Operations said that committee members will not be rubber stamps to the decisions already made by the PCLU, and he was supported by Mr. Khampepe of NIA, who said they are prepared to go through volumes of records in all cases. I may add here that not one docket was read by them. I wanted at some stage to dish out the dockets, but they were not interested. Not one was read. Now in paragraph 3, in paragraph 3, he says, the first subsequent meeting of the TRC committee was held on 25th October 2006, on which day both myself and Advocate Ackerman provided audit reports of the matters at hand. I received a list of such matters from Superintendent Louis Bester of the Unit Crimes Against the State, who was placed in custody of all the files which were previously removed from the offices of the Director of Public Prosecutions, Pretoria, where they were dealt with by Advocate Fick, and later on the PCL, together with retired investigators who were appointed on contract by SAPS, that's Henny, Brits and Nell. A more detailed report was requested from me, and I indicated I would request Brits to assist me, as I was never personally involved in any of the matters. Advocate Ackerman, in a memorandum attached to the revised report, faxed to me on 3rd November, objected against Brits being appointed to assist. I will later deal with this list that Superintendent Louis Bester sent to him. My answer to that was, that will be page 105 at paragraph 3. The reason why I objected to the appointment of Brits as an investigator is cogently set out in the following extracts from PCL report. Paragraph 228 of the report compiled for the task team on 30 October 2006.
Mr. Ackerman, before you read that long stretch that's part of your memorandum, my recollection is that this is already in the record. You've already explained to the Commission that Brits was a former member of the security branch and he had connections with Johan van der Merwe and the Foundation for Equality Before the Law. So I don't think, just to save time, I don't think there's a need to read that out unless there's anything else you wish to bring to the attention of the Commission.
I agree. Then I see, that's paragraph 3. Paragraph 4, see, there is no paragraph 4. I will then deal with paragraph 5. I just want to make sure what
There is a paragraph 4. It's on page 3 of that document. It's page 63 of your bundle.
Let me deal with paragraph 4, where it says the following in his affidavit. I revised the South African Police Service report and requested Superintendent Louis Brits to provide me with a list of all the matters which were according to the documentation at his disposal outstanding. I was referred to a number of decisions took by Advocate Ackerman where it was not clear whether the inquest in those matters were finalized. The revised report was submitted to the meeting on 6 November 2006. It was decided at the meeting that the discussion of the report would stand over until the next meeting. Advocate Ackerman informed the meeting that the decision to prosecute the suspects in the complaint of Reverend Sekane had already been made, namely to proceed with the prosecution. It was minuted by Superintendent Lekala, also referred to as Lucia, indicated to the meeting that recommendations of the task team are necessary because the National Commissioner is of the view that Reverend Sekane is not interested in prosecution in the matter. It was minuted that it was decided that Reverend Sekane's attitude must be ascertained and the matter was therefore closed pending a feedback on his attitude. May I just state here, I see I didn't deal with it in my report back to Piccoli, but you will see that in the beginning of that letter it stated that we best provide him with a list of the documentation at his disposal that is outstanding. And the matters that he referred to was the very first matter was, of course, the landmine campaign inquest. There's a document, I will on page 19. Information note.
Mr. Ackerman, can you just pause for a moment while we locate that document? I'm led to believe that you are referring to the bundle put up by Advocate McAdam, and I understand that that bundle has been supplied to the commissioners and hopefully the other parties as well. Have they been given? I've been told that everybody now has a copy of the relevant documents from the McAdam bundle that is on the website. It's under statements and submissions, then statements, then NPA, and then if you go to Priority Crime Litigation Unit, and then Advocate McAdam, and then the documents under McAdam's name. And Mr. Ackerman is about to refer to page 19, which is titled Information Note. You may proceed, Mr. Ackerman.
That's some other matter here. I just read these documents that were referred to me and appeared on my tablet. And I do not know from whom it came. I just read, so I cannot refer you to from whom I received it. It was on the website that I read it. Now, this is a document to Assistant Commissioner P.J. Jacobs, TRC Related Matters Inquest, As far as the finalization of certain inquests are concerned, the following cases were perused and the findings are as follows. Chair, if we refer to the landmine case, I've disposed of that case. And I've written a long report in it, and I think in this report, I mentioned what happened. That's a forged letter. I said that inquest, people were prosecuted, prisoners died. I declined to prosecute against the president, and an inquest was held. And somebody said, I think it must be Chris McAdam, sent me some documents, the J56. That is the front page of an inquest. And we have the front page of the inquest, that inquests were held. So when Bester and Jacobs state that these matters were outstanding, I don't know what they refer to, but what I do know, they made sure that it is in some sort of report. I can, on page 21, which is page 20 and 21, and 23 of the J56 of the landmine campaign, the inquests that were held. These are documents that they sent to the task team saying they are outstanding. I don't know why they state it is outstanding. I was under the impression I gave instructions what to do with these cases. But of course, what's important, there is a note that the difficult decision about the president and the 37. They give the impression that they was not aware of that. I haven't got the answer in my on the document that I referred to Mr. Corey. Now I will deal with paragraph 5.
Just before you proceed, Mr. Ackerman, I'm advised by my team that particular bundle from the McAdam volume can be referred to as Exhibit 9 of the McAdam bundle.
I'm not handling it.
I beg your pardon. I'm advised that we wish to add it as Exhibit 9 of the Ackerman bundle. So the idea is to put these pages into the McAdam bundle. That's bundle 3 of the Collata group. It'll be Exhibit 9.
Exhibit 9, not item 9. Exhibit 9.
Exhibit 9 of Ackerman's bundle 3 of the Collata group bundles.
Oh, okay.
Now,
Can I understand, but that means that we have this new exhibit, but Mr. McAdam is going to have another exhibit of the same documents. Is that what we are supposed to understand? I don't know whether you understand, my learned friend understands the question.
It is correct, Commissioners, that those pages are in the McAdam bundle, but since Mr. Ackerman wishes to rely on them, we thought of also adding those particular documents to his bundle. But we're in your hands. We don't have. I accept that there might be some duplication there, and if you want to avoid duplication, well, then we'll simply leave them in the McAdam bundle.
Yes. I think a duplication will not be too frightening a measure to take.
Well, in that case, we will add them as Exhibit 9 to the McAdams Bundle 3. Thank you, Chairperson. Mr. Ackerman, you can proceed.
I will now deal with paragraph 5 of the affidavit of Commissioner Jacobs. He says, the revised SAPS audit report was discussed at the next meeting, namely the meeting of 16th November 2006. Advocate Ackerman was furious about the SAPS report and once again referred to Superintendent Britt's prosecution of the President. Dr. Ramahiti inquired from Advocate Ackerman about the relevance of his query. Upon inquiry from Advocate Ackerman, I confirmed that I have compiled the report and that SAPS needed guidance on how to deal with the outstanding inquest. But I then wrote back in the report to Mr. Piccoli, in paragraph 3, is page 107. I say, embarrassed, I say it always, I will do my best to be brief. It is correct that I was furious when SAPS presented their report. The reasons are...
And Mr. Ackerman, on the question of being brief, I see it's a very long response. Is there a chance that you could perhaps summarize for the Commission your response?
I won't be able to do it because all points are relevant. I cannot even recall what I said.
Okay.
So,
please proceed.
Since 2003, Commissioner Celebi furnished the President and the ANC leadership with false information. In essence, the false information was that the PCLU was planning to arrest the President and other high-ranking ANC officials. One of the documents used by Commissioner Celebi was a personal note which I drafted in 2003 and filed in the police docket. That is the forged letter. In early 2004, the former Minister of Justice, Mr. Manduna, informed Mr. Nuka that Commissioner Celebi had alleged that I was on the verge of arresting the President. These allegations were investigated by Mr. Nuka and found to be untrue. A press statement was released in middle 2004 to the effect that there was no case against the President. These false allegations by Commissioner Celebi persisted during the period 2004 and 2006. Advocate Piccoli will be able to provide the details there. During, I think, July 2006, Advocate Piccoli apparently had a meeting with Ministers of Government. Commissioner Celebi was also present, and once again it was raised that I was pursuing an investigation against the President. Advocate Piccoli apparently requested the meeting to provide him with proof of such an investigation. Commissioner Celebi apparently told the meeting that he had proof of the investigation in writing and pointed to a file he had with him. On 16 November 2006, Commissioner Jaco presented the report at the task team. This is a meeting where I was furious. The minutes of the meeting do not reflect everything what was said at this meeting. For instance, I inquired about the meaning of the date 26 June 2006, which was in brackets on page 2 of the report. He did not provide me with an answer. At the time, I was of the opinion that it was the date on which a report had been written by SAPS and that it was an excerpt from a SAPS report. I left it at that. Commissioners, of course, at that stage, I didn't know the existence of the forged letter. That was that the date of 26 of June 2006, I found very strange, and I wanted to inquire what was it. The document provided by Commissioner De Beer indicated that it had been typed on 26th of June and not 2006 and not 26th of June 2003. Everything then fell into
Mr. Ackerman, you actually left out paragraph 14.
Yeah. In paragraph 14, in August 2007, as a result of a report in the Rapport newspaper, I requested Commissioner De Beer to send me my office note, which had been filed in the police docket. And the docket provided by Commissioner De Beer indicated that it had been typed on 26 June 2006 and not 26 June 2003. Everything then fell into place. Advocate Picoli instructed an investigation into the matter. The minister's letter to Picoli speaks for itself. It is obviously that the document Celebi referred to was this forged office note. On 17 September 2007, SAPS informed McCarthy that the office note had in fact been created in 2003. It is now common cause between SAPS and the MPA that my office note was written on 26 June 2003 and not 26 2006. Madam Chair, I don't know why I put in that paragraph, because at a later stage I was informed that I must advance reasons why I am not prosecuted for perjury. And I will refer to that document. So it doesn't make sense to me that they admitted, because they were the ones, according to McCarthy, who asked that I must furnish reasons why I should not be prosecuted. The question, however, remains whether Commissioner Jacob was bona fide when he presented the SAPS report. It is significant that in that report which he compiled, he drafted it in the following manner. Advocate Ackerman indicated on 11 August 2003. On this page 2. On 13 August 2003, Ackerman decided that. Next page, Advocate Ackerman indicated on 4 September 2003 that. Advocate Ackerman decided on 3 October that. And yet, when the President's case is involved, a date of 26 June 2006 is inserted in brackets. It is significant that Commissioner Jacobs failed to insert his customary set because it's an error. I also attach a copy of my report to Advocate Leonard McCarthy, as well as a copy of my affidavit in connection with the investigation as reflected in annexures. A copy of the forged document is attached here to as Annexure A. What happened is then that at some stage McCarthy called me in and said he had a discussion with, I was under the impression it is Commissioners De Beer and Jacobs, and they stated that they are the view that I committed perjury and I must advance the reasons why I made this false affidavit. In fact, I did draft an affidavit. If I say draft, I immediately left it to Chris McAdam to deal with the matter and ask him. I gave him the facts to draft my affidavit. Now, this affidavit you find on page 121. I do not intend to go through the whole affidavit. There's only one long paragraph in Mr. Adams' style, and that will be on page 126. And that sets
So
out...
just before you proceed, Mr. Ackerman, so I just want to check that the commissioners and the parties are on the same page. It's in the same bundle at page 121. At the top it says E. It's your affidavit. This is an unsigned version. It's dated 21st August 2007. You can proceed.
I think the gist of this document is paragraph 14 on page 126. And this is how Mr. McAdam drafted what happened, transpired, and I think this is the document that referred to that is the perjury. Do you want me to read out that paragraph 14? It's a repeat of what I stated.
Yes, it is a repeat. And frankly, Mr. Ackerman, unless there's something different that you wish to draw attention to, I don't think it's necessary to read it, given that from what I can see, it's repeating the facts around the forged letter.
And paragraph 15 and 16 is also, I don't have to read that. That is just that this is the perjury I've committed. I, of course, then had to report to McCarthy. I just want to get that. I have it here. It's on page 190.
119.
119.
So that internal memorandum from yourself to Advocate McCarthy of the DSO, that's dated 27 September 2007. The subject matter is Project Gnome, and it's obviously an Annex D. What do you want to highlight in this document?
I will read out this document because that I was directed to advance reasons why I should not be prosecuted for perjury. Now I feel at that moment, because it was obvious to me that the document was forged, but now I have to advance reasons. I said, dear Leonard, I shall be brief. I am adamant and 100% sure that the figure 6, as reflected in the handwriting's expert document, is not my handwriting. And I'm still of the view that any person, you don't need a handwriting expert to see that it's not my 6. You look at the slants, it's not even close. And on all the surrounding facts, this document was not written in 2006. And I say I'm of the view that you don't need a handwriting expert to establish that fact. Furthermore, it is important to note that the handwriting expert makes no such finding and merely remark, with no alteration to the last figure 6. There's no alteration, it was a completely different person that wrote that. Within minutes after I received the said memorandum from Commissioner Jacobs, I phoned him and informed him that the memorandum was forged and requested him to furnish me with the original. To date, I have not had sight of the original. It is incomprehensible that somebody will post-date by 3 years on a document to predate to predate the year during the months of January is quite common, but to post-date it is not that common. I've never on any occasion written to Dr. Remiti in Afrikaans. The crucial question is whether any person in SAPS had a motive or reason to produce a document emanating from the NPA to the effect that the NPA was still investigating office bearers in 2006. If no such motive exists, then I must accept that the gravamen of the disputed document falls away. Kindly find attached hereby a letter from the Minister to Advocate Piccoli. She said, I'm very interested to know which documents the National Commissioner produced to support his argument that indeed there is an investigation by, I can't read what it says here, on certain political office bearers.
I think it's likely, Mr. Ackerman, that it's by the NPA on certain political office bearers.
If the disputed document is relied on by the National Commissioner to prove that it's needed indeed an investigation by the NPA and ANC office bearers, then that will contradict the explanation given by Commissioner De Beer and Yops to the effect that SAPS were fully aware that the disputed document had been, I can't read mine, it's cut off. But in any event, it is, perhaps we should also refer to the handwriting experts report. I see that Commissioner Yops said, I read it on the website, the documents were submitted. I do not have it with me.
Okay, we will find that handwriting report.
In any event, I took photos of the 6. I cannot see that they, in fact, make any report on it. Some of the findings are nonsensical, and it will take a long time to go through their report. In the event, if it's accepted by the Commission that this is a forged document, we don't need to go through all these documents that I'm going to rely on.
So, Mr. Ackerman, just for the record, the handwriting report is attached to the affidavit of former Assistant Commissioner Jacobs, the one that he filed before this commission. But I agree that there is no need to go through that forensic report.
Those are the handwriting experts of the police. What in fact also happened, and if we go and look at affidavit that Commissioner Jacobs submitted to this commission, it appears that he is still of the view that that document is forged. I refer you to that is a sworn affidavit by Jacobs in the Judicial Commission of Inquiry into allegations regarding the attempts. This commission, I hope that he submitted an affidavit. And in paragraph 71 of this affidavit, it's page 18, I see.
Just to be clear, Mr. Ackerman, you're referring to the affidavit of Philippus Christoffel Jacobs filed before this commission. And are you referring to paragraph 71 on page 18 of his affidavit?
That's correct, Commissioners. Can I read it out?
Yes, you may.
Paragraph 71, Commissioner Jacobs said the following. From Senior Superintendent Britt's affidavit, it was made clear that the note drafted by Advocate Ackerman was filed and received with these other documents in 2003. However, the said note bore the date 23 June 2006 as opposed to 23rd of June 2003. It was further confirmed by means of forensic investigation that the note in question was signed by Advocate Ackerman. The ink, paper and other characteristics on the document were found to be consistent with each other and that there were no alterations made to it. In essence, the conclusion made by the forensic report was that the note in question was not forged. Paragraph 72, he says, on 30 August 2007, the disputed note, together with a file consisting of documents 72, containing 72 specimen signatures and a copy of the facts received from Advocate Ackerman was provided to the late Brigadier Harten, the Director of Forensic Document Consultants, an independent consultant for a second opinion on the disputed document. His report was signed on 31st August 2007 and confirmed the initial report. I think that is now that this document was not forged.
And what is your response to those two paragraphs?
Commissioner, you don't know how it feels to be powerless. You have handwriting experts, you have the police, they've proven a case that I committed perjury on a document that is so patently, blatantly forged. Just the mere fact that Tia Pinar was not even in my office. I don't know if she was even alive when that letter was typed. I know Chris McAdam in his affidavit, the affidavit he drafted on my behalf, stated that, I don't know if he used words like also pain and anguish, but we were both shocked that they could make such a decision. And I think what is also important is the fact, and I will just deal with it now, then go back to the me. What's it? Chair, may I have a short adjournment just to get order in my thoughts?
Mr. Ackerman, how much time would you need?
Just 15 minutes to lie down and get some oxygen in my head.
Okay. Chairperson, would a 15-minute
Yes.
break be in order?
We'll adjourn for 15 minutes.
As the Commission pleases. The Commission pleases. Commissioners, we're about to move to a new topic that Mr. Ackerman just wanted to draw your attention to minutes of the interdepartmental task team, which reflects some of the evidence that he has given this morning. And that's at, the first minute is dated the 6th of November 2006. That's at pages 70 to 71 of his bundle. And the next task team meeting is the one held on 16th November 2006, and that's at pages 79 to 80 of his bundle. Mr. Ackerman, I just want to put to you a passage from the affidavit of Advocate Vusi Pekoli. Commissioners, that's Advocate Pekoli's affidavit in Colata Group Bundle 2. His affidavit dated the 6th of May 2015 is at pages 1 to 47. And I'm going to refer Mr. Ackerman to a passage that starts on page 24 of that Bundle 2. And it's at paragraph 64 of Advocate Pekoli's affidavit. Mr. Ackerman, that paragraph reads, those at the meeting demanded answers from me about TRC prosecutions. And just to be clear, this is a meeting that's referred to in paragraph 62. It's a meeting of the Justice, Crime Prevention and Security Cabinet Committee on Post-TRC Matters, held on the 23rd of August 2007. Attendees included Commissioner Celebi, Cabinet Ministers and other DGs. Apparently Cabinet Ministers present included Minister for National Intelligence Services, Mr. Ronnie Castrals, Justice Minister Mabandla, and Minister Skuyia, among others. So paragraph 64. Those at the meeting demanded answers from me about TRC prosecutions. They were also particularly concerned that I was instituting an investigation into certain members of the South African Police Service. This was in relation to my investigation into who was behind the fabrication of the letter purportedly written by Ackerman SC. Minister Mabandla told me to stop this investigation as we could not be seen to be taking each other to court. I advised the Minister that I would not stop the investigation. Were you aware that Minister Mabandla had asked NDPP Pekoli to stop that investigation?
I was aware of that fact. And 10 years later, it's prescribed. The matter was never investigated. I might add, I suddenly realized that there's a document somewhere where Chris McAdam wrote to Mrs. Steenkamp of the Scorpion, asking her for the investigations documents of the fabrication, because he was also involved in it. And Mrs. Steenkamp wrote back to him stating she can't find those documents. It's not in the archives.
Yes, well, you have a good memory, Mr. Ackerman, but I don't think it's possible for us right now to locate that document unless you can direct us to it. Can I suggest that we don't pursue that particular point unless you have it before you and you can advise us?
I have the document here.
Can you tell us which bundle? And
it's page 130 of the McAdams, of my bundle. it my bundle? I didn't even realize I had a bundle here.
So it's page 130 of the Ackerman bundle.
Yes.
If you just give us a moment to get to it. Okay, so that document is titled Internal Memorandum. It's dated the 3rd of December 2009, and it's from Mr. P. Steenkamp, who's the Principal Admin Officer of the BG team, to Advocate McAdam, Deputy Director of Public Prosecutions, and the subject matter is Project Gnome. Please advise who Ms. Steenkamp was and what was the BG team.
I don't know, Commissioners. I just remembered it was Ms. P. Steenkamp. It says a Principal Admin Officer. I don't know.
Okay. You may go ahead and highlight what you wish from this document.
She says, Dear Advocate McAdam, I confirm receiving a formal request from you to make available the original Project Gnome file. I also confirm that such a file was opened by a special investigating component of the DSO in 2007. This component was disbanded with the closure of the DSO in 2009, and substantial material was transferred out of the office. At the time I was in charge of the component's records. I've diligently researched the office to locate the file, but have been unable to do so. I have also personally contacted the former Chief Investigating Officer, who is also unaware of the current whereabouts of the file. The file was dealt with by a senior investigator near Piet van der Merwe, who resigned last year. All that I've been able to locate are copies of various documents which I attached here to. I do not know why Chris requested these documents.
And just so that we all know, what is this Project Gnome, spelled G-N-O-M-E?
That is, the DSO give all their investigations name. And this was Project Gnome, and that was now the investigation with regard to this fabricated note.
I see. Is there anything further you wish to add in relation to this document?
No, that's all. None of it's relevant.
All right. If there's nothing further, Mr. Ackerman, can we then move to a topic that you wish to deal with, the hacking of your office computer?
Of course, that document, the notes that I've written will be on typist computer. So I requested my secretary at that stage, Mrs. Swan, to search for the note A15, that's a fabricated document, on our computer. She did find it, and it was identical to the document that Commissioner Yops produced, namely this forged document. I was shocked and realized that my computer was hacked. Mr. McAdam then took over and requested that the hacking be investigated by an outside expert. I did not get involved with the investigator in the investigation. A few days later, Mr. McAdam or Mr. Swart reported to me that the expert found that the hacking of my computer did take place and that it occurred from a computer in Durban or from the office of our IT expert at the VGM building. I know the person is Marnus. I probably asked him to do something on our computer. Most probably this hacking occurred from a computer in Durban. It's our office in Durban.
And was there a report generated in relation to the hacking by that expert?
I asked for the report for this commission. We wrote, I think, in my affidavit, I stated that I would like to have a report of this expert. Plus, I wanted to know the cost, because when I looked at the cost, we had to pay them, and it's usually a fight. Is it now out of my budget, or is it out of the Mr. Pikoli's budget? But that's why I know that there was this expert who investigated the matter.
But that report hasn't been recovered as yet.
No.
And while we're on documents, you mentioned that your secretary, Mrs. Zwart, spelled with a Z, she found the note A15, the original or the identical on your computer. Is there a copy of that original document available?
No, not that I know of. Look, in these reports, there are many annexures. These annexures, for instance, these documents were not furnished to us. But for instance, what we've done is probably 10 of these office notes were recovered. Just to show, for instance, A40 was written on a certain date, 2003. A15, that's now the fabricated document, was written 2006. A16 was written in 2003, and the rest. So the only document that was out of sync was the fabricated document. So obviously it's not in sync with the other documents and the dates. But I don't know if there is a copy. I'm quite certain she made a copy for me at the time, and I'm quite certain that it was handed to the investigators and to the computer expert who investigated the hacking. But I didn't have those documents. Chris was involved. I didn't want to form part of that documents. That's why he also compiled my affidavit.
So you would still want the Commission to endeavour to recover the annexes you refer to, and Commissioners, these are the annexes that were attached to the document that Mr. Ackerman sent to Advocate Pikoli on 16 May 2006, and that's at page 7 of the Ackerman bundle. And if you just peruse through that internal memorandum, classified secret, there are a number of annexes attached. When this memo was recovered, the annexes were not provided. Mr. Ackerman would be grateful if attempts could be made to recover those annexes.
And of course, from Commissioner Jacobs or the police, it's only this morning when I went through the document, the fabricated document, that there's no page 2. Maybe they couldn't fit in a page 2. I'm not sure, but it's the first time I've noticed that no page 2 was submitted to us. That's now when Commissioner Jacobs sent the document to Mr. Pikoli.
So you would want the Commission to endeavour to recover page 2 of the fabricated note A15. Is there anything further that you want to add in relation to the hacking, or can we move from that topic?
We can move from that topic.
Then I believe the final issue you wish to deal with in your evidence is in relation to the role of then Minister of Justice Bridget Mabandla. If you're ready, you may proceed.
Commissioners, over the years there were many anecdotal rumors relating to Minister Mabandla's competence as Minister of Justice. I will not refer to them, and I don't take it into consideration. I will tell you about my personal experiences with her. On the 17th of July 2007, Ramaiti and I were summoned to her office. We were summoned on the back of a memorandum that Pikoli had sent to the Minister on the 10th of July to inform her that the Shokani prosecution had been set down for hearing on the 17th of August of 2007. Now, present at this meeting, I must say that Mr. Pikoli could not attend this meeting because he was on compassionate leave, and Dr. Ramaiti was acting, and the two of us then went. We arrived at the office of the Department of Justice. Present at the meeting was myself, Ramaiti, and Mr. Simelane, the Director General of Justice. The Minister arrived with two large black attaché cases in her hand, and put it down, apologized that she was a bit late, and told us that she was on leave, but had to work during her leave, and pointing at the two black attaché cases. She then proceeded to inform us that she was under the firm impression that there were not going to be prosecutions of TRC cases. Ramaiti or myself then explained to her that the NDPP made a decision to prosecute the perpetrators of the Shokani poisoning. She then inquired why was she not informed of this prosecution. I told her that she was informed and produced a copy of a letter addressed to her with a stamp of justice and a signature on it.
Perhaps if you can just pause there for a moment. Commissioners, that meeting and the exchange is referred to in the affidavit of then DPP Pikoli. It's in his bundle, the Kalata Group volume bundle 2, in his affidavit of 6th May 2015. And the relevant paragraphs are paragraphs 56 through to 58. That's on page 22 of bundle 2. You may proceed, Mr. Ackerman.
And if I remember correctly, this was the memorandum, as I said, that Pikoli had sent to her the week before. She asked me whose signature was on the document and who received it on behalf of the Department of Justice. Of course, I did not know. She then asked Mr. Simelane, who looked at it and stated that it was the signature of her secretary. Simelane was then instructed to call the secretary. The secretary came in and she was asked about this letter and inquired why was it not given to her. The secretary walked to the black attaché case, opened it, took out the original letter and gave it to the minister. I noticed that Mr. Simelane was cringing with embarrassment. That settled, the meeting proceeded and she inquired from me whether I intended prosecuting other TRC cases. I answered in the affirmative and started off with the PECO 3 case, which was in the Gilberta Supreme Court role. I explained to her that we could not proceed with the trial because the defense lodged review proceedings to overturn the decision not to grant amnesty to the accused. She then inquired from me, now what is the defense doing in this matter? I was taken aback and didn't know how to reply. Mr. Simelane, again appearing extremely embarrassed, said to Minister, Mr. Ackerman was referring to the advocates appearing for the accused, not the Department of Defense. That day when I walked out, I thought for myself that, let me rather not say. Now, the instruction was given that there's quite a few number of incidents demonstrating Minister Mbandla's competence, and this just derived from TRC matters. The first is the instruction that was given to Dr. Ramihiti in November 2004 to stop the Shikani prosecution and all other investigations and prosecutions of TRC cases. It constituted blatant interference with the work of the NPA. Secondly, the failure to apply the audi alteram partem principle is to establish the facts of the forged document. She simply accepted Commissioner Celebi's version that the document was forged, was not forged. The minister also supported the request by Mr. Simelane, the maid to Picoli, to have me removed from TRC cases. And it's, according to me, indefensible that he did not acknowledge receipt of Mr. Picoli's memorandum to her.
If we can can we just pause? Which memorandum are you referring to?
Is that secret memorandum of, I'm not sure, was it the one that you wrote to her about the problems regarding decisions on TRC matters?
Commissioners, that that secret internal memorandum addressed by Advocate Picoli to Minister Mabandla is in Colata Group Volume Bundle 2 at page 56. It is dated 15th February 2007, and it's titled Prosecution of Offences Emanating from Conflicts of the Past, Interpretation of Prosecution Policy and Guidelines. When Mr. Picoli gives evidence, he will talk to it, but just to give context to what Mr. Ackerman is saying, I can draw your attention to perhaps the last page of that memorandum, which is on page 66 of Bundle 2. Perhaps I'll just read into the record the last three paragraphs and then pose a question to Mr. Ackerman. So at 5.2, Mr. Picoli writes, I have now reached a point where I honestly believe that there is improper interference with my work and that I am hindered and or obstructed from carrying out my functions on this particular matter. Legally, I have reached a dead end. 5.3, it would appear that there is a general expectation on the part of the Department of Justice and Constitutional Development, SAPS and NIA, that there will be no prosecutions and that I must play along. My conscience and oath of office that I took does not allow that. And lastly, 5.4, based on the above, I cannot proceed further with these TRC matters in accordance with normal legal processes and prosecuting mandate of the NPA as originally envisaged by government. Therefore, and in view of the fact that the NPA prosecutes on behalf of the state, I am waiting government's directions on this matter. So you mentioned, Mr. Ackerman, that Minister Mabandla did not respond to that memo, and what was the point you wished to make?
Commissioners, it's such an important document that I would have expected her within an hour to acknowledge the receipt of that document and inform him that he will be informed in due course what decisions he has taken on or how this matter could be settled. I spoke to his secretary. How I know about it was Kaliani Pillay was there, and I know they were all surprised that the minister did not answer or acknowledge even this letter. I don't think it was ever done. I don't know what happened afterwards. Anything else?
Is there anything else you wish to add in relation to Minister Mabandla?
Oh, of course, we have already dealt with the matter that she instructed that the criminal case investigation of the forged letter incident must be stopped. I've got here the minister instructed Mr. Pikoli not to proceed with the investigation of a criminal matter. And that's an obstruction of the course of justice. It's a crime if you stop an investigation. Commissioner, I feel very strongly about this, that she also played a major role in the suspension from office of an honorable person, a man with integrity, and he was fired just like that. That's how I feel the incompetence of her. It was the president had to decide between who he's going to fire, Mr. Pikoli or Mr. Mabandla, and he got rid of Mr. Pikoli. There's just one other matter that I would like to discuss and give my views on. It's about the interaction I had with Wagenaar and the crimes he committed, and the ministers from part of and Celebi were also the perpetrators of that crime. And that is during the period 2002 to 2006. My interaction with Mr. Wagenaar pertaining to the PETCO 3 and Frank Chikane criminal cases, he on a number of times, and I've given evidence on that, threatened me with a private prosecution of the leaders of the 37 ANC leaders. And if I proceed with the PETCO 3 and Chikane matters, I've given evidence on that, I think just now too. It was in 2006 when he threatened me again. I informed him that if he threatened me one more time, I will go to the Silverton police station and lay a criminal charge against him. He asked me what the crime was. I did not inform him. The crime I had in mind was the crime of compounding an offense. And I am the opinion that both the parties, the ANC, if I say the ANC, I mean Mr. Celebi and the ministers, committed that crime. If I may just set out what the elements is of this crime is the crime where a party agrees to drop criminal charges against accused persons on agreed set of facts. The elements are knowledge of all the crime, agreement not to prosecute, receipt of some benefit. Both the police as well as the other police and the ANC members were part of that, were perpetrators of that crime. And that was the whole purpose of this threats that were branded all the time.
Thank you, Mr. Ackerman. Anything further from your side?
I have nothing.
Mr. Ackerman, we really wish to thank you. You've gone beyond the call of duty for a man in your condition. I think most people in your condition would have politely declined to put oneself through such an ordeal. So on behalf of the families, we wish to thank you for appearing the last few days. Thank you for doing an incredible amount of homework. We also wish to thank you for your service to South Africa. You're an old school prosecutor in the best traditions of justice. So the families thank you for your pursuit of justice without fear or favour. Commissioners, we have no further questions.
Thank you, Mr. Vani. Ms. Moroka, any clarificatory questions?
No, Chair.
Thank you. Mr. Kwala?
Thank you, Chairperson. It will just be 2 questions. Justice Home.
If you could raise your voice, Mr. Kwala.
Thank you, Chairperson. Mr. Ackerman, I just have 2 questions. One relates to the affidavit that you read into the record of the former President Mbeki. I hope you remember the context, but I will give it to you. It was a setting where Advocate Pikoli came to inform former President Mbeki about the pending arrest of former Commissioner Mr. Slebe. Was that arrest, the intended arrest or the impending arrest, had it have anything to do with the TRC cases? Was he going to be arrested in relation to an offense relating to TRC cases?
To my knowledge, no. It was in connection with a case that was investigated against Commissioner Slebe.
I was asking that because I understood you to be saying you understood that to be an interference. I thought you meant an interference in so far as the inquiry is concerned. Sorry, I spoke whilst you were speaking.
No, I'm taking your point.
Oh, okay. The second point I want clarity on. You may know, or you may not know, that we had evidence of Dr. Ramaite. You have said something in relation to that. You say he called you and told you that he had received a call from Minister Mabandla that we must put on hold the prosecution. And then later you made a statement, he instructed me to stop the arrest and not proceed with the prosecution. What I want to know is, clarity on is, did you understand this instruction to be that there will be no prosecution of the TRC cases, or that it was a temporal measure to stop the prosecution whilst the prosecution policy is developed?
That was what he told me, that all investigations must be stopped till the formulation of the policy that will be done by the cluster he mentioned something about the cluster, the Director Generals will formulate a policy. And indeed, it happened.
Okay, so I must understand that to mean it was a temporal measure to allow the policy to be developed, and after which the prosecutions could continue.
That's how I understood it.
Okay, thank you, Chairman.
Thank you, Mr. Kwala. Is there anyone I am missing who may have joined virtually who would want to put clarificatory questions to Advocate Ackerman?
Chair, I'm not virtual, but the junior on behalf of the SAPS, the surname is Profi.
The surname is?
Profi.
Profi. Yes,
Chair.
Mr. Profi.
Chair, I just have two questions for clarity. The remaining of the questions will be taken
Yes.
up in cross-examination. Mr. Ackerman, the first question is, in yesterday's evidence, you gave a list of meetings which you don't have personal knowledge to, and began that list with the DG Forum, the HOD departmental team, and ended that list with the interdepartmental task team, but then referred to minutes of the ITT. Was it intentional to include the ITT in that list?
Look, I formed part of that. At some stage, I realized there was going to be a task team to decide on these matters. So I didn't know about this interdepartmental task team till the amended policy came out. And then it was established, this interdepartmental task team. I may add that I'm of the view that the policy does not make provision for an interdepartmental task team. Simply state that there must be 4 or 5 different people of different departments that must assist in the investigation of TRC cases.
The clarity I just thought was that the ITT should not be a part of the list of meetings you have no personal knowledge in respect of.
At what stage?
No, I'm just referring to yesterday's evidence when you were asked about the meetings you attended. You said, I've got no personal knowledge, and then listed the forums. You have no personal knowledge of their meetings or their minutes, and the ITT was one of them.
No, I wasn't part of the ITT. You know, you've referred to the ITT. I just know about the task team. Are you referring to the task team which I formed part of? Is that the team?
Correct.
You talk about? So of course I knew about it.
That's the point I just wanted clarity on. The second
So
point.
Yeah.
The second point is in respect of Commissioner Jacobs. You had started that evidence with even Commissioner Jacobs agreed with you that the document was forged, and then read paragraph 70 of his affidavit. And that paragraph ends with that it was not forged. So if you can just provide clarity in respect of the aspect you agree with Commissioner Jacobs in respect of that paragraph.
Just what is it? I've read that paragraph and was under the impression that he still maintains that it is a forged document. I cannot accept. Yeah.
Now, I'm just saying that you said that he agrees with you that it is a forged document, but in the affidavit, the paragraph you refer to ends with that it's not a forgery. So which aspect of the paragraph are you saying that even Commissioner Jacobs agrees with you?
I cannot recall. Well, you know, if you ask me whether I'm of the view that he knew about the forgery beforehand, I can't answer that. But I don't know at what stage it was decided by, he realized that it is a false statement. All I know is that Leonard McCarthy told me that I must advance reasons why I must not be prosecuted.
Chair, I'm not going to take it any further. The remainder
Yes.
of it I'll leave for cross-examination.
Thank you, Mr. Profi. Mr. Siminya?
Thank you, Chair, Commissioners. With your permission, Chair, we had intimated to my learned colleague for the credit call that we would not be ready to do any questioning at this time. We still are to consider the papers. And with his agreement and to Advocate Ackerman's thanks, he has agreed to make himself available on Thursday and Friday of next week, which is 12 and 13. With your permission, Chair, would the questions by the evidence leaders to Advocate Ackerman be postponed to those 2 days?
Yes. Do we have any application to cross-examine Mr. Ackerman?
Not, Chair,
For now?
for now.
Yes.
I'm sorry, Chair.
If we may, Chair.
May SC go first?
Yes.
We were going to say, Chair, that we do reserve the right to cross-examine. We have 14 days within which to notify Mr. Ackerman of our intention to cross-examine and which documents we're going to rely on. We haven't, because we're waiting for the end of his examination in chief to then apply for leave to cross-examine.
Yes. You intend to bring that application?
For sure, Chair.
Yes. Mr. Siminya?
Chair, if I may just...
Oh, yes.
My apologies, Chair. It is Vivian Rekotso from the Johannesburg Bar on behalf of Mr. Smelani. I'm the junior.
Or
on the
Miss,
matter.
come again with your name?
Vivian Rekotso.
Rekotso.
Correct. I am the junior on the matter on behalf of Mr. Smelani.
Yes.
Chair, we have sent in an application to cross-examine Mr. Ackerman. However, we have not received a response with regards to that as yet. I think we sent the application the beginning of this week to cross-examine, and I think in light of the allegations that were put against our client yesterday especially, and into today, we still stand firm on that application that we would definitely want
Yes.
to cross-examine
Yes.
Mr. Ackerman.
Yes.
Chair, might I ask,
I think the Secretary has indicated that such an application was never received, but maybe Sabine wants to deal with that.
Ms. Rekotso, I am not aware of having received an application to cross-examine Advocate Ackerman from Mr. Simelane.
Chair, we sent it, I think, on Monday, but we will send it again to the Secretary. And we sent in an application to lead our witness on this morning to the Commission. But for the cross-examination, I think we sent it earlier this week.
Yes, I'm not aware of it.
We will resend it, Chair.
Please check with the Secretary.
Will do so.
Okay.
Chair, might I ask for a short stand down to engage with Madam Moroka on the 14 days?
Yes. We'll take a short adjournment.
Chairperson, before we stand down, I think it might be expeditious if we can just complete our re-examination. There are just two or three
Yes.
things we wish to clear up.
Yes,
Yes.
you may.
Mr. Ackerman, let me first start with what the junior counsel for the SAPS put to you, Mr. Profti. And let's first start with the question he raised in relation to the interdepartmental task team, the so-called ITT. And he put it to you that you had said that you were not part of meetings of various bodies, such as the DG's Forum, the Amnesty Task Team, the ITT, and so on. I don't have the full list in front of me now. But he put it to you that you were in fact part of meetings of a task team. And I don't think Mr. Profti might be aware that there were in fact two task teams. And you in fact were referring to one and he was referring to another. And I think that is the source of the confusion. So your evidence, as I recall it, was that you were not part of the Amnesty Task Team and you were not part of the Interdepartmental Task Team created under that Amnesty Task Team to make recommendations to the Amnesty Task Team, who in turn would make recommendations to the Directors General Forum. This is now back in 2004. Is that correct?
That's correct.
But once the guidelines, the so-called guidelines, which we now know as the amendments to the prosecution policy, a task team was then set up to deal with those TRC cases, and that you did attend some of those task team meetings.
That's correct.
Okay. Then let's move to the other point raised by Mr. Prof. D. He put it to you that you had agreed with former Assistant Commissioner Jacobs that the forensic report determined that the note in question was not forged. I think we need to clear that up. Commissioners, we did refer to those paragraphs. That's in the affidavit of Mr. Jacobs before this commission. It's on the website. We're not aware of what bundle it's in at the moment, but it's at page 18 of his affidavit. That's his affidavit dated 26 February 2026, paragraph 71 to 72. And in fact, Mr. Ackerman read those two paragraphs into the record, and he was asked for his response to Mr. Jacobs' claims that there was a conclusion that the question was not forged. And Mr. Ackerman, my recollection is that your response, when I asked you what was your response to those two paragraphs, that you said you vehemently disagreed with Mr. Jacobs' claim that the note was not forged.
That's correct.
And then lastly, if we can just turn to a matter raised by my learned friend, Mr. Gwala. He put it to you that in relation to Minister Mabandla approaching Dr. Ramaita to put the TRC cases on hold, and you were then duly instructed to do so. And as you mentioned, pending the formulation of guidelines, Mr. Gwala put it to you that this was just a temporary situation and that it didn't stop the prosecutions from going ahead at a later stage. Now, I am aware that you were removed from the TRC cases in and around October of 2007. But once the guidelines had been put in place, and let's recall that they were promulgated at the end of 2005 and really came into effect in early 2006. Did the introduction of those guidelines end up resuscitating the TRC cases?
Well, at least one was the Shakani matter that we proceeded with, but other matters, we were not the investigating agencies and there were not police investigators available to investigate all the matters. But there's at least one case that we proceeded with in terms of the amended policy.
And if I recall correctly, that Chakani attempted murder matter was able to go ahead because it had been investigated previously.
Yes, it was completely investigated. We could proceed as soon as the policy came into operation in end of 2005.
So bar the Chakani matter, which had already been investigated, the introduction of the guidelines did not open the door to the balance of the TRC cases going forward.
But because the lack of investigating capacity.
No further questions.
Thank you. We'll take a short adjournment. Have you spoken to the secretary?
Yes, Chair, I have spoken to the secretary. It seems there's some sort of confusion. We thought the letter had been sent, or the application to cross-examine Mr. Ackerman had been sent. She has not received the application.
No application was sent, Mr. Khotso.
Yes, she has not
I
received.
mean, that's a fact.
Correct. Well, yes, Chair. On that score, we tender our apology for having placed on record that an application to cross-examine had been sent. However, we will definitely send in an application to cross-examine the witness.
Yes.
Over the weekend, I suppose by Monday it would have been received.
Thank you. Ms. Moroka, you will accordingly do so. Make your application to cross-examine Advocate Ackerman.
Yes, Chair. It was about the difference or the difficulty was about dates and when we are going to be obliged to do so.
Yes.
We've come to an understanding. Thank you,
Yes. Thank you.
Chairperson,
Yes, Mr.
Mr. Ackerman has asked whether he may be released.
Yes. Is Advocate Ackerman here?
Yes, he's online with us.
Yes. Advocate Ackerman, we express our profound gratitude to you for having availed yourself to give evidence in chief before this commission, given your medical condition. We really appreciate it. You will be recalled for cross-examination on the 19th and 20th of March this year. You are excused, sir, as a witness.
As the Commission pleases.
Chair, the next available date for the formal hearings would be the 11th, the date on which Mr. Nuka will receive questions from us at least.
Yes.
Chair, if I may understand that, so is Mr. Sminya saying Monday, Tuesday, there will not be a sitting?
Yes. Mr. Vani, we confirm that Mr. Nuka will be cross-examined on the 11th.
Yes, our understanding is that arrangement has been made and confirmed.
Yes.
Commissioners, the evidence leaders had asked whether we could again make contact with Mr. Demisa and Sabeze about the possibility of him appearing on the Monday, because as I understand, currently we don't have a witness on Monday. I'm waiting to hear back from Mr. Nsebeza, and as soon as I do, I will advise the Commission. Then secondly, because of the change in scheduling, I quickly approached Mr. Pekori to see whether he might be available to step in on the days originally scheduled for the cross-examination of Mr. Ackerman. He's just advised me that he is available. So with the leave of the Commission and the evidence leaders, he could appear on the 12th and 13th of next week. That's Thursday and Friday.
12th and 13th.
Yes, Commissioner.
You will arrange that with Mr. Seminya.
Yes, we did discuss it in the break, but we just had to approach Mr. Pekori first. And as we were speaking, I just received a message indicating that he would be available.
Yes. Yes.
There is one further matter from our side, Chairperson, and that is in relation to certain documentation. We were advised that Mr. Lawson Naidu had sent a number of documents to the Commission dealing with statements and other documents that were before the Ginwala Commission. We've had no sight of those documents, but we understand that certain of the documents, an affidavit from former Minister Mabandla and an affidavit from Advocate Menzi Simelane are part of the documents, but we've been advised by the Commission that presently they can't be released. And we're of the view that that's a decision that the Commission ought to make. And our view is that documents relevant to the terms of reference of this Commission ought to be released to the Commission and the parties. And if there are any reasons why those documents should be held back, then they need to be placed on the record. Indeed, we were even hoping to put those documents to Mr. Ackerman because we suspect that they might have been relevant for his evidence, but that opportunity passed us.
Yes, Mr. Vani. I mean, that matter will be taken up with the Commission.
We'd be grateful,
Yes.
Chairperson.
Chair, if I may, for the record, we had a discussion with Mr. Semenya yesterday about those documents. Our instructions are that there has been communication between the evidence leaders and the department, and that the department was looking at releasing and giving the Commission those documents. I'm not sure what Mr. Vani is trying to imply by insisting that there is a refusal of some sort.
Yes. Thank you, Ms. Moroka, for that explanation. I think the matter will be taken up by the Commission, Mr. Vani, and we'll leave it at that.
As the Commission pleases. One last query from our side. Mr. Semenya mentioned that Mr. Nguku would appear on the 11th. We just want to check, is Advocate Simelane not scheduled to appear on Tuesday the 10th?
Chair, I would have to confer with my scheduling colleagues, and I thought if we get rid of this one, you and I will see whether or not there is any impact. But for now, the cross-examination of Mr. Nguka will happen on the 11th.
Okay, just in terms of scheduling, does that mean that currently Monday and Tuesday are not set down? And if so, what is the situation with Advocate Simelane?
We haven't received, we've got to comply with the rules of this Commission. You've got to apply timeously to lead the evidence in chief of your witness. You've got to be given a directive granting you permission to lead that evidence, and that request has not been made timeously.
Okay, Chairperson. So under those circumstances, Advocate Simelane won't be appearing next Tuesday then?
As far as we are concerned, there will be no hearing on the 10th of March for Advocate Simelane.
Noted, Chairperson.
Yes. Ms. Moroka, you seem to be having a querying face.
Not for you, Chair, because I thought I did ask the question and you did give a response. So
Yes.
I'm not very sure what Mr. Vani is asking.
Okay.
I asked a specific question because I wanted to understand the scheduling, and you gave an answer. So it's not a querying face towards you, Chair.
Thank you.
It's a pretty face towards you.
And you are pretty, I can confirm that. These proceedings are therefore adjourned until the 11th of March at 10 hours when the cross-examination of Advocate Nguka will proceed.
As the Commission pleases.
We are adjourned.